Hello, I'm attorney Carol Avard, and I'm going to prepare you for your medical examination. Basically, there are two types of medical exams that you may be asked to attend. They are physical exams and mental exams. The physical exams are done by doctors who either work for insurance companies, the government, or defendants' attorneys, and generally their loyalty is with them and not with you. That means it is very possible their incentive is to find that there is nothing whatsoever wrong with you. While this is not always the case, it is usually the case. The exception is if your attorney is sending you out for an evaluation. Basically, you want to be sure that the doctor has all of your medical records when he or she evaluates you. If they do not have all of your medical records, it can later be argued in court that the exam was not thorough. It is up to the doctor to make sure that the medical records were received. It is not up to you to supply the medical records unless ordered to do so. Do not provide the doctor with medical records unless your attorney tells you to do so. Your attorney will provide records if they are pertinent or relevant. Ask the doctor what medical records he or she was given to review and make notes about what he or she did not review when you get home. Tell your attorney what medical records the doctor had to review before the doctor examined you. You should wear a watch and time the exam. Some doctors only spend 5 minutes with the patient, but they write reports looking like they spent hours with the patient. Many doctors come to the conclusion that you are not disabled or you are not injured based on a 5-minute evaluation. If it is a personal injury case, other doctors may want to say that your injuries were due to other causes or they existed before your accidental injuries. If your present injuries were definitely caused by this accident, make sure you tell the doctor that any previous injuries you had are not related to this incident, that they were treated and cured, or that they have not been symptomatic in a very long time. If you can, bring a friend, a spouse, or a relative into the examining room. It is a good idea because you will have a witness. If this is not allowed, see if you can bring a tape recorder. If you cannot do this, just complete the form your attorney will give you and make sure you complete it immediately after the exam. Other doctors like to imply in their reports that there was nothing wrong with you because you drove yourself to the doctor's office, and therefore you would not be in any pain and you could not be suffering. They may also write in reports that you showed up for the appointment on time, implying you had no difficulty with memory or implying you would have no difficulty getting to work on time. Other doctors may write in reports that you were neatly dressed, your hair was combed, etc., and therefore you must feel good about yourself in spite of your pain. In other words, there was no obvious evidence you were suffering from any pain. I have also seen reports that say the patient sat in the doctor's waiting room for more than a half an hour without any evidence of pain. So if you need to stand up after sitting in pain, please do so. If you use a cane or any other assistive device, make sure you take it with you to the doctor's appointment. If you have a friend or a relative who can drive you to the appointment, make sure you tell the doctor how you got to the appointment and why you could not drive yourself. Many clients cannot drive because they are in too much pain or because they have side effects from all the medication that they take and it makes them too drowsy to drive. Other doctors have their staff, like a nurse or a secretary, do the evaluation, and the doctor comes in after it is done and asks only a few questions just so he or she can bill for the exam. Obviously, this is not a comprehensive evaluation. You may be asked to get up on the examining table. Look to see whether or not the doctor observed you get onto the examining table. We frequently see reports from doctors that say the patient jumped up on the examining table without any difficulty or evidence of pain, and therefore the patient does not have a serious medical condition. If you have problems getting onto the examining table, you must ask for help getting on the table. Record this fact on the form your attorney will give you to complete after the exam. The doctor may also ask you to do a range of motion test and will supposedly measure how well you can move every part of your body. For example, if you have a neck injury, you may be asked to turn your head to the right, turn your head to the left, or move your head down to your chest, or move your head up to look at the ceiling. If you have any pain at all doing this activity, you must tell the doctor that it hurts to move your neck or your head. If you hurt your lower back, you may be asked to bend over, to touch your toes, to stoop, to lift, or any other number of movements that would affect your back. Once again, if you have back pain during these movements, you must complain that it hurts to do these activities. Again, note this on the form that you will complete for your attorney after the exam. If you have nerve damage, and this results in numbness to your hands, your fingers, or your feet, the doctor may stick needles in your hands or feet to see if you do not feel anything. The doctor may ask you to write something using a pen, type on a computer, or pick up a coin from the table. This is all done to see if you really have nerve damage. If you have pain that radiates, this may indicate very serious damage to your spine. For example, if you have a neck injury, pain can radiate into an arm or a hand. And if you have a low back injury, pain can radiate into a leg or a foot. Make sure you tell the doctor about any pain that radiates. If you have numbness in the hand, this may be due to nerve damage in the neck. If you have numbness in the foot, this may be due to nerve damage in the lower spine. Make sure you tell the doctor about any of these symptoms, as they represent very serious damages. In a range of motion test, you may also be asked to move your arms, use your fingers, and use your hands for grasping, pinching, or reaching if these parts of your body have been injured. If you cannot grasp, pinch, or reach, you must not attempt to do more than what your limitations are when you are examined by the doctor. We see many reports from doctors' exams saying the patient had no problems squeezing with the hand, no problems pinching or picking up coins off a table or buttoning a shirt. Once again, the purpose of the exam is to document your injuries, not to show you can do more than what you usually do on a regular basis. Similar issues arise if there are injuries or medical disabilities related to the hips. Any attempt by the doctor to get you to do more than what you can normally do should be objected to, and you should complain about the pain the doctor is causing you. If you are with a nurse and the nurse asks you to remove your clothes, sometimes they will report the patient had no difficulty removing the clothes, no difficulty unbuttoning or buttoning a shirt, no difficulty pulling a sweater up over the head. So make sure you ask for help if you need this kind of help. If you are having a cardiac stress test or a lung function test, you must remember that if you are exhausted from exercising on a cardiac stress test, you must tell the doctor to stop the test. If you are unable to breathe into a breathing machine due to a lung disorder, you need to tell the doctor this. Do not overexert yourself on these tests. If you are going for a psychiatric exam and psychological testing is performed, we have been told by some clients that the psychologist actually tells them what the answers are. Sometimes the doctor even repeats the answers on the memory testing. We were also informed that another doctor told a client to erase an answer that indicated she was suicidal. Please never erase any answers. Clearly, this violates protocol. If the test cannot be completed in one day, the test results are sometimes considered not valid. We were also informed by a client that he was told to take the MMPI test home and to ask family members what the answers were if he could not remember an answer. No test should ever be taken home, since it cannot be verified who gave the answers to the questions. The MMPI is a test of 567 true or false questions. It's also designed to see if you can sit long enough and designed to see if you can concentrate and focus long enough. If you cannot answer 30 or more questions on this true or false test, the test results are not valid. So if you get to that point, you need to complain that you can't do any more. If you do not speak English well, the test must be given in your native language. Never take the same test twice, as this will result in higher grades the second time. Psychological tests frequently are designed to determine how your daily activities, social functioning, concentration, and memory are changed by your medical conditions. If you are not impaired in these areas, you most likely are not disabled or injured. Therefore, if you stay home and don't socialize, you need to say so. If you cannot do household activities because you are too depressed, or if you are unable to concentrate on reading a newspaper or watching TV because you are bothered by your own depression, or even if your pain interferes with concentration, let the doctor know how many minutes you are able to concentrate on these activities. Finally, they want to know, are you capable of persisting on any task without being bothered by your own impairments? If you cannot complete simple tasks, follow simple instructions, or remember simple instructions, be sure you tell the doctor. For example, if you are unable to remember directions if you are lost on the street, or are you unable to remember a simple telephone number from a caller if you do not have a pencil? If 5 minutes later you find the pencil to write the phone number down and you still cannot remember the number, then you would have serious memory problems. The doctors may ask you to spell world backwards, or you may be given 7 numbers, and the doctor will ask you to subtract the number 3 from each number. If you can do this, you may not be disabled, since this will show that you can concentrate quite well and you are not bothered by your pain or depression. If you have a personal injury case rather than a disability case, you may be asked about your spouse. With personal injury cases, the spouse is entitled to damages for those activities you are no longer able to do. For example, if your pain prevents you from doing certain household activities like cooking, cleaning, cutting the lawn, etc., the value of that task can be determined based on what you may have to pay someone else to take over that task. If another family member has to assume the activities, and even if the family member is not getting paid, there is still a value that can be placed on that work. Keep a calendar and write down what you were not able to do, and whom in the family or outside the family had to assume those tasks during your period of convalescence. If you have a personal injury case, your spouse may be entitled to damages for loss of affection and for social activities, loss of social activities. This means that if you are no longer able to have sex with your spouse due to your medical condition, you should tell the doctor about this. If you have a personal injury case and your attorney has made a demand to settle your case, you should read the section in the demand package concerning your injuries. Make sure it is correct and that it includes everything you still have. Make sure you do not forget to tell the doctor about all of your injuries. As stated in your demand package, you must be familiar with any permanent injuries you have. For example, if your doctor said you have a 5% permanent impairment rating in your arm and a 2% in your back, make sure you know these things so that you can report this to the doctor. During an exam, some doctors ask questions that are completely unrelated to the disability or the injury. These questions are not proper, and you should tell the doctor your attorney told you not to answer any questions unrelated to your disability or your injury. For example, a doctor may ask if you have sued other people, paid your income taxes, get along with your spouse, thinking about divorce, or if you have a drinking or a drug problem or a criminal record. These questions should never be answered. Also, doctors should not examine you for medical conditions that are outside of their expertise. For example, if you are seeing a back doctor, the doctor should not ask you about your vision. The doctor should never ask you about how the accident happened. and whether or not certain parties are at fault. Those are legal questions that are unrelated to the medical exams. You should tell the doctor that your attorney directed you not to answer those questions because they are too far afield from the medical evaluation. Who is or is not negligent is only a legal question. Whether or not you had a seatbelt on is not really relevant. Whether or not you had the brakes tested on your car is none of the doctor's business. Just remember, the point of the exam is to determine the extent of your disability. Remember to talk about where you experience pain and how the pain prevents you from doing things like sitting, lifting, standing, walking, concentrating, and remembering simple things. For example, anyone who can lift a gallon of milk, which weighs about 8 pounds, or sit for more than 30 minutes without severe pain, stand for more than 30 minutes without severe pain, concentrate or remember what was on TV after 10 minutes is clearly disabled or seriously injured. Do not exaggerate, but also do not forget to mention your real pain and functional limitations. Thank you for allowing us to help you prepare for your medical exam.